Welcome to Canadian Justice. I'm Christine Van Geyn, and today we're talking about a recent ruling from the Quebec Court of Appeal on Bill 21. Passed by the National Assembly of Quebec in 2019, Bill 21 prohibits public servants from wearing religious symbols or clothing while on the job, ostensibly in an effort to preserve the religious neutrality of the state. The bill was justified on the grounds of a French concept called laïcité. Laïcité is a notion of more than just separation of church and state and freedom of religion. It creates freedom from religion as well, based on the concept of a totally neutral state. The law applies to public employees in positions of authority from wearing religious symbols while on duty, and it applies to jobs like teachers, crown prosecutors, judges, police officers, and others. It prohibits them from wearing symbols like a hijab, a kippah, or a cross. In order to avoid a legal challenge on the basis of the charter-protected right to freedom of religion, Quebec preemptively invoked the notwithstanding clause, Section 33 of the Charter. But the law was still challenged as a violation of religious freedom. Here today to discuss the outcome of the appeal are two experts, Derek Ross of Christian Legal Fellowship and Guillaume Rousseau, who is a professor of law at University of Sherbrooke. Thank you both so much for joining me today. Derek, let's talk first about this law and what it does. How does it apply and who does it apply to?
Sure. Well, as you mentioned, Christine, Bill 21 is a Quebec law that purports to entrench laïcité or a secular neutrality as an official doctrine in Quebec and requires that all institutions, all public institutions in Quebec be neutral. And that itself is not controversial. What is controversial is the means by which the law purports to advance that laïcité or that neutrality. And it does that, as you mentioned, by banning the wearing of religious symbols in certain public spaces. And specifically, it applies to a number of positions, prescribed positions set out in the legislation, where individuals who work for certain government agencies, lawyers who work for the government, school teachers, police officers, a number of other prescribed roles are prohibited from wearing religious symbols at work. And so the concern that that has raised, that groups like Christian Legal Fellowship and others have raised, is that that effectively excludes religious minorities and others who openly identify with their religion from public participation. It excludes them from the right of equal access to public service on the basis of their religion.
Derek, do we have any information about people who have either left their job or been fired from their job because of Bill 21? Is there any information about that?
I know there was some data that was being collected. I don't think that the evidence was declared upon or issued in the court ruling. I personally know of some colleagues, and one in particular, a lawyer who wears a hijab as an expression of her faith, who has not been able to seek her position that she had always wanted to as a public prosecutor in Quebec.
Now, Guillaume, I mentioned in the introduction, and Derek has referenced it as well, that this is about this French notion of laïcité. Can you explain? I did give a bit of an explanation, but is there anything you want to add about what laïcité means? Is it uniquely French? And how it's viewed as an important concept in Quebec?
Yeah, laicité is similar to secularism, but secularism is more sociological, while laicité is more political. I think that would be one difference. And if you look at Section 2 of the Act respecting the laicity of the state, you really see the four elements of laicity, and they are separation of state and religion, religious neutrality of the state, equality of all citizens, and in the French version is citoyen et citoyenne, so basically equality of all citizens, male or female, and freedom of conscience and religion. And what is very important to look at also is Section 4, because in Section 4, the Act creates a right to secular public services and secular institution to the extent provided in the Act respecting the laicity of the state. Therefore, there is the prohibition of the wearing of religious symbols. It prohibits also all civil servants from covering their face, because if you go for a service from the government and you are faced with some civil servant with the face covered for religious reason, while well, you don't have a right to secular public services, or you have that right, and that right
We,
is being violated.
we've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing Bill 21 in Quebec, which is their religious symbols law, and a recent decision from the Quebec Court of Appeal related to that law. Now, Derek, Guillaume, both of you were involved in the case in some way. Christian Legal Fellowship, Derek, was an intervener in the case, and Guillaume, you were counsel for an intervener. So I'd be interested in hearing the positions that both of you or your organizations took in the case. Let's start with you, Guillaume.
Yeah, so my client, the Mouvement Laïque Québécois, is part of the trial to support the position of the Attorney General of Quebec, and therefore to support Bill 21. And we have some argument that are a little different from the argument of the AG. I can maybe explain it to you later. But also, what's very important is that we add witnesses. So we had parents, and most of them Muslim, by the way, who came in front of the judge and said that they support the bill, that they want their children to go to public secular school, and they don't want their children to be under religious pressures.
Which is actually a sort of feature of interventions in Quebec that is not common or not possible in other parts of Canada. Typically, an intervener would not be able to lead new evidence, but in Quebec, there is a possibility of doing that. So that's an interesting procedural quirk for our lawyers who are watching. Derek, what about you? What did Christian Legal Fellowship argue as an intervener?
So CLF, as an association of religious lawyers, is deeply concerned about any rule that would effectively exclude individuals from working within parts of the legal profession based on their openly religious identity. CLF specifically raised concerns about the impact of this law on religious freedom and religious equality, both of which are protected in the Charter of Quebec and in the Canadian Charter. As we might talk about, though, those protections, their operations are suspended because the government invoked the notwithstanding clause. But we raised the argument that there are other protections for religious freedom and for the right of all religious citizens to equally access public institutions that exist outside of the charter. And one of the questions that we asked the court to address was, what is the nature of those constitutional protections? The charter was introduced in 1982, but it did not introduce religious freedom to Canada for the first time. Unfortunately, though, pre-charter case law didn't necessarily resolve unequivocally the state of religious freedom in Canada. So there are certain questions that the courts still need to look at in terms of protections for religion that exist outside of the charter. And those were the issues that we brought to bear in our intervention.
So one of the things that's interesting to me, and that it's my perception, is that this is actually a fairly popular law in Quebec. Perhaps both of you can maybe comment on that. Now, of course, our rights are not contingent on being popular or unpopular. They're constitutionally protected, or they're not. But perhaps you could both comment on the public perception of the law in Quebec and outside of Quebec. Starting with you, Guillaume.
Yes, it's a very popular law. We see it in surveys. We see it last election. The CAQ government, which adopted that law, was re-elected with a landslide victory. So it's pretty clear that the law is popular. And if you look at the survey, a similar law would be less popular in other provinces. Would be maybe 50-50, but in Quebec it's much more, at least 2/3 or even more people support the bill. There are many reasons for that. Maybe the influence of France, where laws about laicity go even further. Also, the history of Quebec. There used to be in Quebec just one big church. There was many churches, but one big church, the Catholic Church, which was very influential. And for some people, it was just too much. So people that are old enough to remember the Quebec before the Quiet Revolution, they know that when religion is too influential in the public sphere, that becomes a problem. And then we also have immigrants from, example, from North Africa. They came here because they escaped radical Islam in their own country, and they fight for secularism as well.
Derek, what's your view on the popularity of the law? We've only got about 30 seconds.
Well, I think, as Professor Rousseau mentioned, there are a number of reasons people support the law in Quebec, and there are polls in other provinces that suggest others, at least a third of respondents in other provinces would support a similar law. But I think lost in that sometimes is the nuance of the impact this has on minorities, and that's precisely why human rights are protected in our Constitution, is to reflect that minorities need protection in cases where even laws have popular support.
We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing Quebec's religious symbols law, Bill 21, and a recent Court of Appeal decision about that case. Now, before talking about the Court of Appeal decision, I want to talk about Section 33, which is, you mentioned it in one of the previous segments, Derek. Section 33, the notwithstanding clause, it was invoked in this case. Perhaps you can explain what Section 33 does, how it applied in this case, and what might have happened to the law if it had not been invoked.
Sure. So Section 33 is a provision of the Charter. It has not been invoked ever by the federal government. It has been invoked on occasion by provincial governments, and it was, of course, invoked in the context of this legislation. Section 33 effectively allows a law to operate, even though it might violate certain protections entrenched in the Charter. Specifically, Section 2 of the Charter, which protects the fundamental freedom of religion and expression, among others, and also Section 7 through 15 of the Charter. And Section 15 also protects equality on the basis of religion. So when that notwithstanding clause is invoked, the law operates as if those provisions do not apply, or at least it allows the law to operate as if those provisions do not apply. And so what that means, practically speaking, is that the court will not strike down a law on the basis that it violates those provisions. And that's essentially what happened in this litigation and in the Court of Appeals decision, that the court felt that because of the invocation of Section 33, it could not consider the Section 2 religious freedom claims and the Section 15 equality claims. As a result of that, there was not a determination of whether the law violated those provisions, and if it did, whether the law could be saved under Section 1 of the Charter, which allows the government to justify limitations placed on certain provisions. So those are all still open questions.
Yeah, so this is one of the real key parts of the decision that could have broad, really broad implications. Guillaume, this issue of the law was invoked, Section 33 was invoked preemptively. And if that law has, if Section 33 has been invoked, can a court still review the law? Or would a declaration a court issues be moot, like of no value? So what did the court find on this question of can they issue declarations once, or even review a law once Section 33 has been invoked? What did the Court of Appeal hold in that?
Well, basically, what the court is saying is that when it comes to Section 2 and 7 to 15, then Section 33, the notwithstanding clause, applies, and there's nothing the court can do about it. It's sovereignty of Parliament that prevails. And when it comes to Section 3 to 6 and 16 to 23, then it's the supremacy of the judicial power that applies. Section 33 doesn't apply. So what the court did, especially at the Superior Court, but also to some extent at the level of the Court of Appeal, is to use Section 3 to 6 and 16 to 33 to challenge, to look at the act and to see if it respect those human rights, and Section 1 of the Canadian Charter that allows to justify some limitation of some rights was applied, and in the ruling of the Superior Court. So that's basically the way Section 33 works. On the one hand, you have sovereignty of Parliament for some section. On the other end, judicial supremacy on other section. That's all the balance of the Canadian Constitution.
So what's so fascinating to me is that this Quebec Court of Appeal reached that conclusion in this case about moot declarations, that once Section 33 has been invoked, the law is not reviewable. But a different conclusion was reached by a court in Saskatchewan, and there's another case line where a Quebec court is reaching the opposite conclusion. Derek, what can you tell me about that and how these two competing views of Section 33 may come to a head eventually?
Well, I think it reveals that because Section 33 has not been invoked all that often, it really has not been the subject of extensive construction and interpretation by the courts. And it reveals that there are still a lot of questions, very important, pressing questions, that remain to be answered about the exact scope and nature of Section 33 and to what extent it limits judicial review of certain aspects of a claim. Another big question is the extent to which it interacts with other provisions of the Charter. Section 28 of the Charter, for example, which guarantees that rights
Right.
shall be protected equally between male and female
Right.
persons, and also Section 26 and 31.
We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing Quebec's secularism law dealing with religious symbols worn by public sector employees, certain public sector employees, and a recent decision from the Supreme Court, or from the Court of Appeal, the Quebec Court of Appeal. Although I do think there's a good chance this will end up at the Supreme Court. So Derek, we talked about what the Court of Appeal held on Section 33 about these moot declarations, but what was the overall, how would you explain the decision to people who are watching? What really stands out here?
Well, I think what really stands out is that the Court of Appeal essentially rejected almost all of the arguments that were brought by those opposed to the law, and largely did so, relying on the invocation of the notwithstanding clause. And the court was very careful to explain that it was not taking a position on the political wisdom or merits of the law, that it was really limiting its decision to the discrete legal questions. But even its analysis there raises a number of questions that I think would benefit from a closer examination by the Supreme Court. There's a big question here about the division of powers, whether Quebec, as a provincial government, has the jurisdiction to pass a law like Bill 21, which the lower court mentioned effectively imposes a particular ideology, which traditionally was seen as falling within the realm of the criminal law. Now, the lower court ultimately concluded that because there wasn't a penalty attached to it, that it wasn't considered a criminal law. But there are a number of aspects about this legislation that we and others have argued suggest is not within the scope of a province to effectively impose religious conformity, or in this case, irreligious conformity on its citizens. There's questions about the scope of the notwithstanding clause that need to be addressed as well. And for us, primarily, the concern that we raised was that religious freedom does find protection outside of the Constitution. The Court of Appeal effectively concluded that whatever those protections were before, they were superseded when Section 2 of the Charter was introduced, meaning that now Section 33 can effectively suspend that protection. And we are deeply concerned about that. The idea that the notwithstanding clause can potentially claw back on protections for religious freedom that might have existed before the Charter raised the question of, is that all there is to religious freedom in Canada? Is it something that the government can impose any restriction on religious freedom or equality that it wants, so long as it has the necessary majority to invoke the notwithstanding clause? That's a big question that transcends even this case, and I think impacts all of us in a very profound way, and is one that hopefully the Supreme Court will weigh in on.
So Guillaume, what's your take on the decision? What stands out most to you? What's your take? Do you think the court got it right here?
Yeah, it was a unanimous judgment from the Court of Appeal of Quebec, and there's the technical aspect, but the tone, especially compared to the ruling of the Superior Court, the tone of the Court of Appeal is really clear. It's really like, this act is constitutionally valid. There's no discussion. It's really clear the argument are rejected. All of the argument of those who oppose the law are rejected very, very clearly. So that's the first thing. Then about the notwithstanding clause, there is a ruling of the Supreme Court in the Ford case. And basically, what the Court of Appeal is saying is that the way the notwithstanding clause is used in Bill 21 is perfectly in line with the ruling of the Supreme Court on how to use that clause, the ruling in the Ford case. And then there's just one exception, is that the Court of Appeal found that the prohibition to wear religious sign for the president and vice president of the National Assembly breached the right to be candidate at an election. So that's the only exception, the only part of the act that has been found unconstitutional.
And Guillaume, what do you think the likelihood is that this heads to the Supreme Court? They would need to get leave. How likely do you think it is to get leave?
We oppose it. We think that the ruling by the Court of Appeal of Quebec is unanimous. If there was two judges on one side, one judge on the other side, that would invite the Supreme Court to allow the appeal. But it's the unanimous judgment, and
Right.
that's
all the time we have. Forgive me, but thank you both so much for coming on today. We've heard today about the Quebec law that prohibits certain government workers from wearing religious symbols. This law is a very clear limit on religious freedom, a limit that it appears the Quebec government knew when it enacted would not pass charter scrutiny. That's why it invoked Canada's notwithstanding clause, Section 33, to get around this rights violation. Did the Quebec court make the right decision? Or is this a violation of religious freedom that's something that Quebecers and Canadians can't stand for? You be the judge.